Hello, everyone, and welcome to part 2 of our lecture about legal issues when it comes to owning and operating a fitness facility. Last time we talked about the different legal services that you may want to reach out and hire an attorney or a registered agent for. And we also talked about contracts, which are very important because if you're going to own a gym, you want to make sure that your contracts between your members, between your employees, between your vendors lay out clearly what that relationship is. So you can avoid any complications legally, right? And so today we're going to talk about some things that may come up and pop up as far as potential dangers and potential legal actions that may take place if a gym or gym owner doesn't take the proper steps to make sure that their facility is a safe and non-hazardous place to exercise and for people to work, right? So today we'll talk about these tort and civil liabilities. So we'll start with the definition of a tort liability, which is the failure to observe a duty of care or responsibility not to infringe on another's rights by either intentionally or carelessly causing harm or injury, right? And this doesn't need to be just physical harm. When we say injury, it doesn't mean like a broken bone or someone gets cut or anything like that. It can be physical, it can be emotional, or it can be to the property itself. And not only can a member bring about a a lawsuit to a gym, but it could work both ways. If someone damages intentionally, anything on your property, there can be liability there, and there can be a lawsuit that's filed, right? And so the overall goal to file one of these lawsuits and have a litigation is to get some compensation for any damages that may occur, and that's typically damages. When you use that in the legal sense, it talks about the monetary value for any loss or injury as a result of someone's either negligence or wrongdoing, or just money overall. They're going to want to sue for a total amount of that damage or that injury, right? So tort law does not punish wrongdoers, although it's not like criminal law, but they can coincide, right? If someone does harm someone intentionally, physically, there can be a criminal case against them. But tort law is just going to deal with whatever wrongdoing or negligence, whatever monetary value a person's trying to get out of that wrongdoing, right? So it compensates people for legal wrongs that they suffer at the hands of others. So here are some examples of tort liability in the fitness business, right? A injury caused by unsafe facilities, the injury from faulty equipment, failure to properly supervise. And so you can see that if you're running and operating a fitness center, a health center, or a gym, that you need to make sure that you're on top of things, right? So you need to make sure that there aren't pieces of equipment laying out that cause a tripping hazard. You need to make sure that if a machine is broken, that there is a sign on it saying that people cannot use it at that time, and then that you make sure that you call either the vendor that you're working with or you aim to fix it yourself. You still need to make sure that there is a clear sign saying that people can't use it, and it's not going to be able to be used until it is working properly, right? And then you also need to have, when people are exercising, people out there on the floor so they can look out for any potential dangers, or if anyone gets harmed, or God forbid, an emergency happens, they can act appropriately and either carry out CPR or call 911, whatever they need to do. So we are trying to cut down also on not only the things that a gym owner can do to, lower the risk of injury or damage to a person, but we also want to keep an eye on our members and make sure that they are properly using the equipment, that they're not putting anyone else in harm's way. So again, there's the civil versus criminal liability. If there was a wet area and someone trips and falls, you're not going to be held criminally liable, but that person may take you to civil court in order to try to get some monetary value for their injury, right? But criminal liability, that's going to be in intentionally, breaking the law, and there'll be, legal consequences from that as well. So tort liability, there needs to be an understanding that something in, legal terms called duty of care. And so when you have a relationship between a business and a client, and so whether that be a gym and its patron, or a doctor and their patient, a teacher and a student, there is some sort of responsibility for that business or person that is expected that they are responsible for at the benefit of the consumer, right? And so we're establishing first that there is that duty of care between the two parties, and then a breach of that duty in law, right? So, and so if there's a breach in that duty of care and the plaintiff suffered damages due to the breach, well, then they're going to try to sue for financial compensation, right? So here we have different examples of duty of care, the different relationships that would, classify under that. So employer to employee, employer to guest or member, an employee of the gym to a guest or member. So, these are relationships that gyms, fitness facilities, healthcare facilities are going to have every single day. So there is that responsibility to have a safe environment and non-hazardous environment for both employees and members and guests, and to make sure that whether it be your front desk staff, your trainers, your instructors, anyone who works on your property needs to be well aware of the potential dangers that come with working in a fitness facility, right? A vendor is also going to be responsible, right? Independent contractors, so it's not just employees. It's everyone in that facility is going to have a certain responsibility to the members and patrons that work out or take part in that facility. But there are plenty of different relationships here that fall under duty of care: landlord and tenant, property owner, and those who access it, etc. All right, so there are different categories of tort law. So it's classified in what that breach of duty of care was. And one major one the fitness industry entrepreneurs really need to look out for is negligence, right? And negligence is when a duty of care is breached unintentionally, but still causes harm, right? So gyms are supposed to promote a safe workout environment. Whether the patron is working alone or working with somebody, it is still the responsibility of that facility to make sure, again, that it is safe, not only, when they're doing something on the treadmill or something on their, one of their resistance machines, but if they're actually working out with a trained professional, they should be, have proper certification, have proper training and experience in that area, and be paying attention to the client that they're working with, right? If an employee causes the injury while acting within the scope of his or her employment, the employer is held generally liable. So if you do have a personal training session going on in your facility, and someone, breaks a bone, God forbid, or has a serious injury, hits their head hard enough on something, the gym itself is liable for that action. So it's very important to establish these things, and that's why we talked about contracts and documents last time. It's very important to establish not only, okay, what do we do as employees and managers and operators of fitness and facilities to make sure that's a safe place, but the relationship between your employees and your members when they're working out with someone. What are they responsible for? How are they going to promote not only a good workout for the client, but a safe workout for the client, right? And so some recommendations for employees and employers within the fitness industry: make sure there is an adequacy of training and supervision. That's why it's recommended that your personal trainers have certifications, that your higher level fitness staff have 4-year degrees, and that they're keeping an eye. They're keeping an eye on those clients at the time, right? If they see, people with flush skin, clammy skin, they look dazed, the member says they're dizzy, that they're on top of those things and not just trying to, work through it, push through it. No, you need to keep sure that you are promoting that safe environment and not putting anyone at risk for potential injury or potential incidents. Not only because, legally, you could be held liable, but it's also the safe thing to do. You want to make sure that clients feel that they're cared for and that they're protected for, right? Existence of guidelines and procedures, again, making sure that within the employee handbook or whatever documents you have for orientation for your different trainers or employees, that it's clearly laid out their responsibilities and the things that they need to do in order to lower the risk of any incident occurring. Hire appropriately and experienced personnel, and then proof of adequate instructions, notices, warnings, again, so that equipment that you have, if something's broken, even a little thing, make sure that there is a sign on it and that no one is using it and that there's someone on the floor making sure that people aren't going to use it and that people aren't working out in a potentially dangerous way to themselves and the others around you, right? So negligence is not acting in a reasonable, safe, or prudent manner. So, this is probably a silly example, but you have a trainer that tells the person that you're doing 1 rep maxes, right? And which is a very risky thing, and not saying that that shouldn't be done, but let's say, the person's doing 1 rep maxes and then they are, talking to another member while they're on their cell phone and having the person just lift the weight by themselves. So that can be example of negligence, right? And it doesn't need to be, again, one of your staff interacting with a guest or member or patron. It can be when they are just working out on their own. And if you fail to post the proper warnings, that could be an example of negligence, and you could be held liable for their damages or injury. There may be an act of omission, again, like you weren't paying attention to the hazards that were on your gym floor. Someone trips and falls, even though, maybe another member was the one responsible for putting down that weight that they tripped over. You're still held liable. Or, it could be the act of the gym itself that they were negligent, not putting the proper signage, not putting the proper warnings. And that could be an act of commission, right? But there's 3 criteria in order to basically prove that a business or industry was negligent. One is going to first be the duty of care or responsibility, which is basically the legal liability based on the business's responsibility to fill out a duty, or again, responsibility, which the client is benefiting off of, right? So that service that the gym is providing, that's their duty, their responsibility, to keep a safe working environment, and that they have that duty of care, that relationship between them. And then there has to be a failure to perform that duty, again, the breach of the duty. This is what is basically being settled in court. To what extent was that duty breached? And gym owners have to be careful. They have to warn of potential dangers if there are hazards within the facility. And then there has to be injury or damage caused by that breach of duty, right? So the injury, again, it could be physical, it could be emotional, but the plaintiff, the person suing, has to prove that loss, that damage, that injury comes from the breach of duty that was done by the gym, done by the business, done by the facility, right? And then typically, again, the damages placed on that's the value, right? So what is the cost of that injury? What is the monetary value behind the negligence that the gym or potential business did, right? And so we have comparative negligence, which determines the percentage of fault. So that's how a lot of negligence is handled. So to what degree, percentage-wise, is the business responsible. And sometimes, you could say, okay, the business is 90% responsible. Was, the client at the time, were they doing something that added to the negligence, right? So it puts a percentage value, like how much does the client, how much are they actually going to get paid due to the negligence? And, the less they find the business at fault, then the less they're going to pay out. But if they find that it was clearly an act of the facility's wrongdoing, then they're going to get a higher payout percentage of there, right? And then we also have contributory negligence as well, which is if the plaintiff was involved at all in the negligence, there's no compensation. So if they're found to any degree that they're not negligent, then they don't get a payout. And so not a lot of negligence cases are handled like this anymore. Again, I'm no attorney, so you probably want to read up on this elsewhere. But an example of this is if someone is crossing the street and texting on their phone, right? They were texting on their phone, they weren't paying attention, they didn't pay attention if there was a walking sign across the way, and then someone accidentally hits them with a car. Well, of course, there's probably some negligence on both parties, right? But in a contributory negligence manner, the client, if they were, adding at all to that negligence, they don't receive a payout. Where in that comparative situation, again, how most negligence is handled, there is a degree or percentage for both of the parties, right? And so moving on with the different categories, so negligence is one, but then we have things that are called intentional torts, right? Which is intentionally or willfully breaching of duty, right? So if you had a trainer or an instructor who was harassing somebody, right? They're intentionally causing harm or injury to that person. That's an intentional tort, right? And it's going to be a lot easier to prove, hey, this person was malicious and they put someone in harm's way within the facility, and again, your gym, your fitness facility can be held liable. And then we have what's called strict liability torts. So strict liability means that there was an interaction between the facility and the client, and that led to injury. But you don't need negligence or even intentional tort needed to prove it. So again, the injury, not from a specific negligent act, but from inherently dangerous activity or from the manufacturing of an unsafe product, right? So, if maybe the trainer didn't intentionally mean to have someone go through an episode, but if it's a 100-degree day outside, they had them running sprints back and forth, they didn't have them stop for water breaks, even though that may not have been an intentional thing and the trainer may not have had harm by it, that's liability. You're putting someone in harm's way. So again, it's good for the owner or the operator of the facility to discuss that with their employees, and especially that staff line, those staff line employees that are going to have that interaction with the clientele, with the patrons, and actually be implementing fitness programming. You got to have that conversation that, hey, of course, you want your clients pushed, you want them to have success with working out, and you want them to grow and get better, get more healthy. But at the same time, you shouldn't have to put people in harm's way in order to do that, right? And then we also have defamation, which you've probably heard about before, and that's tarnishing the reputation of someone. So again, doesn't need to be physical harm, can be brought about by emotional wrongdoing as well. So what are the responsibilities of the gym? Warn of any known defects on the premises. Again, if there's broken equipment, things aren't operating properly, you got to post signage up. You got to make sure that everyone knows that you're not supposed to use that piece of equipment, right? They're responsible for any unknown defects that could reasonably be discovered, right? So again, just keeping your eye on top of things. That's why it's good if you have fitness staff out on the floor. It's not wrong, like if they want to hop on machines and making sure that everything is working properly, or to have a checklist either weekly or bi-weekly to make sure that not only are you cleaning and taking care of the pieces of equipment that you have, but make sure that they're operating properly so a member isn't the one that's put in harm's way if there is any defects. And then make the premises safe and free from such defects or dangers. So if you have staff on the floor, making sure weights get put back in the proper place, and even, posting the proper signage to employees. Not employees, to members. They should have some sense of responsibility, some sense of care for the facility that they work at. And for you to post a sign to please ask if they could put away equipment where they found it, I don't think that's overstepping whatsoever. But still having the backup, having one of those part-time or full-time employees, make sure that there aren't any tripping hazards or wet spots on the floor, and that there's no potential dangers there, right? And so what are the potential types of dangers? Floor surfaces, how you prep that floor, right? If you put any sort of chemical or, any sort of bleach on a mat, you got to make sure that people aren't using it immediately after, and then covering things up as well. You have the inside facilities, which you have to keep an eye on, all your treadmills, resistance equipment, pulley machines, things like that, and all the locker rooms. Everything can be a potential danger, right? You also need to make sure that not only is that equipment kept up with and clean and operating properly, but people have to be using it properly as well. I do see a lot of people, they sort of take into their own hands and they feel like they know what's right, and they'll use a machine the completely wrong way. They're not allowed to do that, no matter how much they think they know about fitness, whether, they're a YouTube fitness star, whatever. It doesn't matter, right? Everyone has to use the equipment like it's properly designed, because if something goes wrong, you're the one responsible. They're not the one responsible, even though they could have, participated or been a part of the defect. And then the equipment design or manufacturing defects, again, just keep an eye on these things. Make sure you have a checklist, okay? Is everything operating properly? And if not, have we put a sign on it and made sure that we reach out to the vendor, reach out to the manufacturer in order to get it fixed, right? Again, you're responsible. The owner, the operator of the business, they're responsible. But employees can play a part in negligence, right? And so if they fail to monitor the things going on the fitness floor, instruct participants on safety and equipment use, right? So any good aerobics instructor, group fitness instructor, trainer, they should be calling out cues, right? This is what we are taught in the fitness industry. Be loud, be clear, make sure that you are promoting safe workouts, right? Safe exercises. And then, the failure to evaluate participants' ability to participate, right? So knowing that where your clients are on the scale of fitness, right? If they're just starting, don't make grandma be doing wind sprints, right? That's just not safe. There are progressions when it comes to people. If you have an athlete and you can push them to the limit, as long as, again, you're doing it in a safe manner, that's fine. But you have to be realistic where people are in their fitness. And so they're not going to be able to handle certain things. And if you push them too hard, that may be a form of negligence, and you can have bad outcomes happen, right? And it's also important, too, just a side note, with health history questionnaire and getting proper information about your clientele, the medications that they're on, because if a trainer is going to work with them, they need to be aware of these things and be aware of the potential dangers that may come from diseases or medications. So your employees need to be supervising during exercise, provide modifications in class when they're too difficult, making sure the exercise environment is safe, and then individualize exercise testing procedures, right? So if you have a cardiovascular assessment as part of your fitness assessment at your gym, well, do you have an alternative if your baseline fitness testing is a mile run, right, where you're going to base their cardiovascular fitness off a mile run? Well, an obese individual that's been sedentary for 15 years, has high blood pressure, maybe that's not the best test for them. So what alternatives are you going to come up with for proper assessing and then proper programming as well? So it's important, again, to lay out expectations for employees. So either, with an employee handbook or a personnel policy. Employee handbooks typically are going to go over procedures. And so it's going to go over, the annual review process or the resignation or, what benefits somebody has. And then it's also going to go over the guidelines, what's expected of them, what are the opening procedures, what are the closing procedures of the gym if they're working there, what are they responsible for. It's going to have some sort of orientation, how you clock in every single day. And so basically it's going to lay out for the employees not only what, they're expected as far as benefits and, it breaks down into the employee expectations and the employer expectations of what the employee is responsible for. And then, again, so listed here, it's typically shorter and simpler. That personnel policy manual's a little bit bigger. Not only does it deal with employee expectations, employer expectations, but it's going to deal with human resources and administrative procedures as well. And so bigger facilities typically have both, and that personnel policy usually goes to the managers, but still employee handbooks are typically kept at the front desk for employees to look at any time for those orientations, those rules, those guidelines, those procedures. All right. So when you let someone go, there should be an already established reasoning why someone would get laid off, whether it be a sales performance thing or whether it be just a, overall assessment of how they're doing. You should lay out those guidelines for employees to know whether they're having poor performance, what is defined as poor performance, what is general misconduct, what are the things that could lead to termination, basically, right? And so if you find it important, which most fitness centers should, that the front desk staff should not be on their phones, they should not be taking breaks longer than X amount, and they continue to do that, well, there should be that track record, that expectation at the same time that, hey, we have laid out why you were terminated, and this is why you're going to get terminated. Not only that, but you also should have a warnings and notices procedure in place. So what is the nature of unacceptable performance? And then so you're going to warn them a first time. What are the steps that you're going to take in order to solve that? And then, how long are you going to give them before, if they keep up with that activity, if they keep up with that wrongdoing, what are the consequences of that, right? So that should all be defined within that employee handbook there. And then just to wrap it up, some things to pay attention to, especially as a fitness facility owner, the Americans with Disabilities Act, which limits employers' right to discipline or terminate employees for problems related to a disability, right? And of course, you also want to provide accommodations for those with disabilities. This isn't only just, ramps instead of stairs outside of your facility, but also that making sure that any piece of equipment within your gym can be accessed within a wheelchair, right? So you need to make sure that you're not excluding a certain percentage of the population and that you do care about those with disabilities and that you take the proper steps for the safety as well. The DrugFree Workplace Act of 1988 basically lays out that if a full-time employee is going to get insurance and benefits, that they typically need to pass a drug test. And so many full-time staff will have to go through this procedure. So you typically do a background check to make sure, and you typically have a drug test. And this is to make sure that the company is going to invest that money and time into the person and invest with benefits such as insurance and potential retirement plans. And then policy against harassment. And so harassment can be based on sex, race, religion, origin, age, disability. It's a form of discrimination and should be taken very, very, very seriously. And so within those handbooks that you lay out should have a policy, one that clearly states that it is a harassment-free work environment. Nobody, whether it be employees or members, there should be no harassment within your facility's walls. Describes the types of behaviors that are prohibited, because it doesn't need to be, again, physical. It can be sexual harassment, can just be saying certain things to others. So that needs to be clearly laid out within that policy handbook, and then encourages all employees to report incidences to management. You need to lay out, okay, if there is harassment going on, what are the steps that are taking to handle it? And I have attached a link down below from IHRSA, which basically goes over, why it's important to have these harassment policies and different steps that you should take. All right, well, that concludes our lecture here on legal issues when it comes to owning and operating a fitness facility. And future lectures, we're going to talk a little bit about the insurance, and then we're gonna develop a little bit more on professional development. So how to make a resume, sitting through interviews, things like that, because a lot of people won't go and own a gym, but these things are important to understand how these processes work, not only as an owner or an entrepreneur, but an employee, and understand what is expected out of you when you work at a fitness and health facility. All right, thank you guys very much, and I'll see you next lecture.